Doesn't look like we have any yet, so we'll continue making some small talk so people will start logging in. I was asking Robert how the pandemic is affecting, day-to-day stuff in the Valley, and it sounds like it's just like here. But I think Newsom's going to lock down everything. Not everything, but I think next week is going to be, no more indoor dining.
Well, San Francisco's been in the yellow.
Yeah, San Francisco's been doing really well, but I think they're going to get caught up with the rest of the state to some extent.
I agree. I think they're going to go, everyone's going to be in what they call purple, I think.
Yeah, although it'll be interesting to see how you put the genie back in the bottle for some of these places that have opened up and people are getting used to being out and about. I don't know how you could be able to get them back, but we'll see.
Well, New York had to go through the same thing, right? And they're getting they're writing lots of tickets and enforcing. So New York things were getting pretty much back to normal, and then the governor and the mayor are really starting to clamp down now. So there's a model there for putting it back in. But I don't know if that, I think you're right, Robert. This is a different culture, different environment. Is that going to work in Silicon Valley?
I don't see people writing up a lot of tickets. I really don't, unless it gets bad. If it gets bad, yes, but otherwise, I just don't see that happening.
Those of you who are joining us, welcome, and we're just waiting for folks to sign on. We'll probably get going, probably around 10:03, 10:05. So we're just making some small talk here until we get going. Just be patient, and we'll be with you in just a couple of minutes.
So I was going to say, my wife and I are spending Thanksgiving week in San Francisco, so we hope it stays yellow.
Well, we'll see. We'll see.
Yeah, exactly. We're traveling up north as well.
Well, don't bring anything with you when you come.
Kaya.
Well, it's supposed to be nice up here. It's supposed to be nice up here then. So, hopefully things will be open enough where you'll be able to enjoy it.
Yeah, we've been doing this for at least 10 years. So this year obviously be a little different, but hopefully not too different.
Richard, will your daughter be joining you?
No, she comes home this Saturday after Thanksgiving.
How's she doing off in college land?
It's going surprisingly well. It's also very odd because all the kids are kind of isolated. It's hard to meet people much when you're wearing a mask and staying away. But
I can't imagine being a student in college and being socially distanced.
Yeah, well, her school's been very strict. Everyone gets tested twice a week, and they've done really well. But it's and the school's worried with the numbers in the overall country going downhill. Before they come home, they have to pack everything up in boxes in case they get shut down. The school has to ship all their stuff home.
Wow. So did you all read what happened with Notre Dame?
No.
They, at the end of the football game on Saturday, it was a big win for Notre Dame, and apparently all the students rushed onto the field like, students used to do. And because of that, the administration said anybody who leaves campus now cannot come back on without a test. So, right at Thanksgiving time, all these people are going to have tests to be able to prove that they are healthy and not carrying COVID in order to get back on campus if they go off campus.
That's interesting. There's also a flip side to that. I know in the UK, they're testing all the university students, and if they're positive, they can't leave, right? So they don't want to go home and start affecting everyone. So that's kind of going both ways.
Yeah. Yep. Interesting times.
Well, I think everyone's hopeful that when we get a vaccine, that it's able to be distributed efficiently and and fast, and I think a lot of us have short memory. So hopefully in March and April, this will be in our rearview mirror. Hopeful
I
thing.
hope you're right, but we're still talking about another 5 months, right?
Yeah. Those of you who are joining on, we're going to start in just here a couple of minutes. Be patient with us, and we'll get going in here in just a little bit.
Now, Kevin, how's college going for your daughter?
Well, good. She's in community college, and it's all remote, and she loves it. I mean, she didn't take enough classes. This is her first semester, and I think they told her to take 4 classes, and it's just not keeping her busy enough. And so we'll fix that. But yeah, I mean, she loves the remote classes, but I think misses the social interaction.
Sure. That's tough for everyone.
Yeah,
I mean, it was, look, they were seniors in high school when this happened, right? So she missed graduation, prom, all these things, which they'll never get back,
The people I feel for, which may include many people in our audience, are the ones who have young kids who are doing school from home, trying to manage that plus jobs, plus other things. That's just got to be really difficult.
And it's falling unevenly on women, and
Yep.
you'd like to think we live in a kind of a non-sexist society, but the reality is that's often the case, not true. And I think women are getting really overly burdened with some of that. I certainly see it every day. It's it's a big issue because companies want to start getting back to work, and the schools are key to that. Those of you who are joining us, we'll get going here in just a couple of minutes. We're just making some small talk until we get going with our rockstar panelists.
So, Kevin, how long has it been since the High Tech Awards? When was the last one? Do you remember what year?
It was, I think, it's been at least 7 years, I think.
So, about most of the people involved, certainly on the board and things with Tech San Diego, also were involved with the former AEA, American Electronics Association.
This is going to be the 18th annual. I mean, I have full, we do this. This is not the first High Tech Award. This is going to be the 18th annual or 19th. I'll count it out, but it's going to be the 19th,
Well, I think for the community, that's true. And so we used to have this annual event, and I think we always sold out 500 people. It was built around a lunch. It was a couple hours. And pretty much it was a feel-good event. That was the idea, kind of celebrating local tech companies and successes and things. And when AEA closed all the chapters.
A lot of the press goes to 5 companies, right? And so the unicorns, and it gathers, a lot of press gets driven to a small number of tech companies. And the idea of this is for people, like Richard said, people to feel good about the other stuff going on in
Right.
town. And these companies, they're not at the vanguard of, they're not going to be in Wired magazine, right? But they're doing some really good, interesting stuff, treating their employees well, and just, really great companies. And there's really no way to recognize those companies. So we came up with this criteria on the awards to kind of recognize some of those things. And some of it is managing through adversity, right? You don't have a good year every year, but how do you manage through that? And it was also, most awards are huge revenue generating machines for the associations. And so they're charging, $1,500, $2,000, $2,500 for a table. And the smaller companies, they're just not going to do that. And so we charged a small amount of money. I think, back then it was $550 for a table of 10. And, our claim to fame was we had more technology executives in the room than any other event in the region. It wasn't the biggest event, but we had more actual technology executives, right? Because most of the events it's all the service providers who buy all the tables. And so we had the companies buy tables, which was nice.
Sounds great. You need one for the COVID era.
I think people are going to be hungry to it. Once we get to all clear, I mean, that's just, I don't know what that looks like, an all clear signal, but I think we'll know it. And when we get that, I think people will be hungry to get out and network again. I know I mean, that's my job, is to be out networking. And, I think I can barely talk to anyone anymore. Do you shake hands? What are we going to do? Those of you who are joining, we're going to get going in just a couple of minutes here. 10:05, we'll have some people join us later, but we're not going to penalize everyone for registering and logging in at the right time. So just a couple of minutes and we'll get started. Had some interesting roundtables talking about the pandemic, and some folks are trying to think, if things get locked down a little more, how are they going to react to that? So I had a senior manufacturing roundtable last week. They were discussing that. They're sharing a lot of best practices about how to keep their workers safe. It's just interesting, the different issues according to the different titles people have and what they're really focused on. HR was focused on bringing people back. Things were, as people as lesson now, they're not talking about that. They're, they keep on moving that. Some companies are, saying officially next summer.
Yeah, you're fortunate if you have the kind of company where the vast majority of your people can do their work remotely. For the ones who don't, it's a very difficult time.
Yeah, a lot of the high-tech companies up here have said they're not, their employees won't be coming back for the foreseeable future. They'll just all work remotely.
All right, let's go ahead and get started. I'm going to sit up straight here. My name's Kevin Carroll. I'm Executive Director of Tech San Diego. Been really looking forward to this event. I saw a lot of webinars that talked about intellectual property, but they had kind of these weird titles about, the things you need to know about intellectual property, or strategies to create intellectual property. And I was talking to one of our board members and executive committee members, Richard Campbell, who I'll introduce here in a second. And, we really never talked about really the core, why we even have intellectual property, to protect it, right? So I challenged my friends at Procopio to come up with an event that really focuses on, as the title says, protecting the family jewels, because everything else is really secondary to that. So really looking forward to this. Let me go ahead and introduce our two speakers. The first person I'm going to introduce is Bob Sloss, a partner at Procopio. Bob advises clients on matters pertaining to intellectual property, counseling, and litigation. Bob leverages his experience as a senior in-house lawyer at a major technology company to provide a unique set of skills to resolve clients' legal disputes. He has broad experience in litigating patents related to a variety of technologies, including software, computer peripherals, mechanical devices, and biotechnology, as well as matters involving copyright, trademark, and trade secrets. Bob, welcome to the webinar.
Thank you, Kevin.
And I'm going to introduce my friend, Richard Campbell. Richard Campbell also serves on the Tech San Diego Board of Directors and on our executive committee. He's a partner for Procopio. He heads the IP practice. Richard has a formal bio, which I'll go through, but he's known in San Diego as one of the top IP attorneys in town, and people love to have him as a client. And if you're opposing counsel, not so much. Richard concentrates his practice primarily on the creation and execution of intellectual property strategies. He focuses on patent-related matters, technology licensing, developing intellectual property strategies, and related trademark and trade secret matters. Richard has assisted numerous clients, which include startups, established companies, in developing successful patent portfolios. He has worked with companies having a wide range of technologies, including communications, software, electronics, computer networks, lasers, optics, semiconductors, medical devices, and bioinformatics. Richard has a broad range of experience in technology licensing and structuring domestic and international technology transactions. Richard, welcome to the webinar.
Thank you,
Hello,
Kevin.
Richard.
That makes me feel like I should blush, but thank you very much. Bob and I are very glad to have this opportunity. I want to thank you and thank Tech San Diego. And without any further ado, we're going to have Bob kick off our presentation.
Richard, before you start, I'm just going to make one note on the questions. You should see that little question box. Feel free to ask questions. We're going to be monitoring those questions. If I deem it kind of worth interrupting, I get to be the judge on that. So thank you very much. But I got to tell you, typically we won't interrupt till the end. But if you throw a question up there, I can tell you with a high degree of certainty that we'll ask that question. So feel free to put your question in there. We'll be monitoring that, and then we'll come back to those questions, and we'll try to do a Q&A at the end. So didn't mean to interrupt you, Richard. I'm going to go off screen and mute, and we'll leave you guys to do the presentation.
Thank you, Kevin. And good morning, everybody. We were talking before we got started about the days in the future when we'll be able to do this kind of thing live and in person. I think we all look forward to that. But thank you for attending this remotely. Sarah, please, next slide. So with a group of tech people, what better way to start than with a quote from Steve Jobs, certainly one of the great tech people of our era, who said, among other things, innovation distinguishes between a leader and a follower. And I think we all want our companies and our people to be leaders and innovators. And innovating is a great thing, but once you get your innovations, you have to protect it. And that's what this presentation is about. Sarah, please. So I'm going to focus on software because I think it's really all about software in today's world. Software is a major component of pretty much every significant technological advance, whether it's in biotech, where software is used to help do the experiments and come up with the innovations that are created. I like to say, and I'm not the person who first said this, but a car these days, an automobile, is really nothing more than a computer on wheels because of all the software that really goes into it and makes it what it is today. So why protect software? That's what we're here to talk about. First is because it is a valuable asset. In many cases, it's the most or among the most valuable assets a company has. And if it's valuable and if it leads to the success of a company, others are going to want it, whether they take it legally or illegally. They're going to want to copy a good idea. That's what always happens. And so the law has created a number of different tools to help protect software. And what the law will enable you to do if your software is used improperly by somebody else is you can get it back from the courts will help you get it back from whoever is using it improperly. You can get an injunction that will stop someone from exploiting your software, or you can obtain compensation when it's being improperly used. So we're going to talk about the tools that really allow you to do that. Next slide, please. So we're going to be talking about three different kind of legal principles that allow you to protect your software. I'm going to talk about copyrights and trade secrets, and Richard's going to talk primarily about patents. Next, please. So let's start with copyrights. And copyrights have been around for a long, long time, and certainly in this country since the beginning of the nation. They're part of the Constitution, as are patents. As you'll see here, this quote from the Constitution talks about the progress of science and useful arts, but for authors and inventors. And what this does is it gives Congress to enact the authority to enact laws of copyright and patent. And Congress has done that, and it started doing it with the first Congress back in 1789, and it continues to do so today. As I have here in the slide, there's a Copyright Act, which is found in the US statutes at 17 USC section 101. So that is the basis, the foundation for copyright protection. Next slide, please. So what are copyrights? copyright is something that protects the expression of an idea, not the idea itself, but the way it's actually expressed. And we typically think of copyrights as something that applies to books, music, things like that. It has to be an actual something in a tangible form. You know, it's a book, the writing on the page, the music recording, whatever. It has to be something tangible, not just in your mind or an idea or something like that. And one theme about laws and intellectual property and innovation is the laws are always behind. They're trying to catch up to whatever innovation is going on. And so that's true with copyrights. Computer software has been around for at least 80 years, perhaps longer. But it wasn't until 1980 that Congress amended the Copyright Act to provide for the protection of computer programs. And it did it in a way Congress could only do it. It did it by calling computer programs literary works. So that's a little bit of an odd way of getting at it, but the important point is it finally got around to protecting computer software by copyrights. Even though the law has been around for some 40 years now, it's still an issue about what is exactly copyrightable in terms of software. I cite here a Supreme Court case involving companies Lotus and Borland, neither of which is around anymore, I don't believe, but at the time it was a big deal because the issue was whether menu hierarchy is copyrightable, and the court held it is not. More currently, there is kind of an ongoing holy war between Oracle and Google in which the Google Android, which, as you know, appears in Android phones and things like that, uses APIs developed in Java, which is owned by Oracle. And Oracle sued Google back in 2010, and this case is still going on. It's actually before the Supreme Court. Oral arguments were heard last month. So we don't know what the final result will be. One of the issues in that case, though, was whether APIs, which, as you probably know, are application programming interfaces, whether those are protectable as copyrights or not. And if initially the trial court said they were not, the Court of Appeals said they are, and that is now an issue before the Supreme Court. So the point being here that there's still some uncertainty about what exactly in software is copyrightable and what is not. Sarah, next slide, please. Now, copyrights do have, limitations as to what they will protect. There must be some creativity involved. There are court cases that say a phone book, for instance, can't be copyrighted, even though the information, well, primarily because the information is not creative. There's getting a list of names and putting them in alphabetical order is not creative. The same thing with statutes. This is actually a very recent decision which said a state that puts together its statutes in book form cannot copyright that book. There's also a doctrine called fair use, which is very important in copyright law, and it does apply in the software world. And so the idea of fair use is that somebody can copy a small amount of work for transformative purposes. And typically this is in the form of literary commentary or parody, where a small part of a work is copied verbatim, say in a critique of a movie review or something like that. And it's used to describe the movie or the literary work or something like that. Parody is another big area of fair use. And the Pretty Woman case was a Supreme Court case in 1994. Many of you are probably familiar with the song Pretty Woman by Roy Orbison. In the early 90s, there was a rap group called Two Live Crew that did I guess I should call it an X-rated version of Pretty Woman. And the owners of the Pretty Woman copyright sued to stop that or to get money for it. And the Supreme Court held that the use of Pretty Woman and the parts of it that were excerpted in the Two Live Crew version was fair use. Fair use is also one of the key issues in the Oracle Google case because Google contended that only a small number of lines of code, I think the number is 37 or something like that, were copied, and that the copying of such a small number for its purposes was fair use. The lower courts said no, because there was no transformative purpose, that they just took the code and started using it. They didn't change it or use it for any sort of transformative reason. Also, I think another factor was they used it to make money, and that's another consideration when you're talking about fair use. But the issue is before the Supreme Court, so we'll see what happens. Next slide, please. So copyrights are fairly easy to obtain, particularly when you compare them to patents, which Richard will talk about shortly. You actually don't need to register anything to have a copyright. A copyright attaches to a work with the creation of the work. The sort of downside to that is you can have a copyright without registration, but you can't enforce it in court until it's registered. So if you're serious about protecting your copyrighted works, you probably want to register them with the Copyright Office, which is in Washington. It's actually part of the Library of Congress. And it's fairly easy to do. So it really requires payment of a small amount. It can be done online. You have to fill out a form, and you have to submit the copyrighted work to the Library of Congress, where they keep a record of everything that's ever been copyrighted in the US is stored at the Library of Congress. For the most part, a copyright has a very long term. It depends, there are some nuances here, but generally it's about 95 years from when it's first published. And it's changed a lot over the last 35 or 40 years, in large part because of companies like Disney, which don't want their copyrights to expire on some of their key properties. So as of now, the term is 95 years, and so it's a very long time, certainly longer than most software would expect to have any real utility. Next slide, please. If somebody is using your copyrighted work improperly, getting them to stop is fairly straightforward. You bring a lawsuit in federal court. And the copyright owner must show that this is actually something that has been copied. If it's independently developed and they come to the same result, that's not a copyright violation, although that kind of circumstance is rare. In order to show it's been copied, the owner must show that the infringer had access to the copyrighted work, and that the work that's infringing is substantially similar to what is copyrighted. If the owner is successful, they can get an injunction, which stops the other person from using the work, a seizure of the infringing works, and potentially damages. So in a case such as the Google Oracle case, the potential damages are in the billions of dollars. So this is something that can be pretty substantial. Next slide, and I think, yeah, we're ready to hand it off to Richard now. Thank you.
Thanks, Bob. So I'm going to talk about patents, and I'm primarily considered to be a patent lawyer, so that's why. So a patent is a grant from the federal government, and it's the right to, and the right to grant patents is in the U.S. Constitution, as Bob mentioned, Article 1, Section 8, Clause 8. And whenever I tell my 18-year-old daughter that therefore I'm a constitutional lawyer, she just rolls her eyes. Now, a patent is a right to exclude others from making, using, or selling the patented device or method. It's considered to be a negative right because it allows you to stop another party from doing something. It does not give you the right to practice the invention. For example, you can have a patent on a system that includes elements that someone else has patented. For example, say a digital filter. Therefore, you cannot practice your patented system without the permission of the filter patent owner. Patents last 20 years from their filing date. However, it cannot be enforced until it's issued. In general, you can patent an invention if you own the rights, it's new, and not obvious in view of the prior art. We'll come back to these criteria in a moment. Patents and patent applications are assets. For technology companies, patents are typically the most valuable form of IP. Next slide. As I mentioned, they're assets. Like other assets, patents and applications can be sold. Here are 5, say, blockbuster examples of large blocks of patents being sold for very large sums of money. AOL got over $1 billion for just 900 some patents. Microsoft sold over 600 patents for 550 million. Interdigital sold 1,700 patents for 375 million, and so on. So what's a patent worth? By definition, each patent is unique. These examples show a wide range. The AOL patents were worth more than $1 million each, whereas the Fujifilm patents were worth less than $100,000 each. Next slide, please. Now, patents are the right to exclude others from practicing the patented invention. The ultimate enforcement mechanism is a federal lawsuit for patent infringement. However, many infringement type disputes are privately resolved through licensing and payments like that. They can also include cross-licensing, where the parties license each other's patents. When a patent owner is successful in a patent infringement suit, there can be two remedies. One, the court can order the party found to infringe to stop infringing. The court can ban the defendant from making, using, or selling the infringing product during the term of the patent. And two, the court can order a money award to compensate for the prior infringement under the theory of a reasonable royalty or lost profits the patent owner could have made absent the infringing sales. Here are $3 billion verdicts in patent infringement cases, and maybe the Google case will join this list. For example, the famous Apple/Samsung dispute was not the biggest verdict. I believe all these verdicts were appealed and subsequently settled for a reduced amount. Now, patents provide value in other ways. There's a marketing benefit. Identifying patents in your marketing materials and in customer discussions let customers know that certain aspects of the technology are exclusive to your company. It can also lead to interesting information about what your competitors are telling customers about their patents. In general, the existence and knowledge of patents greatly reduces the likelihood that competitors will copy your technology. No one wants a patent lawsuit. Next slide. Because the focus today is software, the first thing that I want to tell you is the Patent Office issues patents on software inventions every week. So in a general sense, software is certainly patentable. There are some nuances in the details. However, the take-home message is do not discount or avoid patents merely because your technology is software. Now on the slide, the first bullet is the legal definition of patentable subject matter. As you can tell, it's very broad. The second bullet lists the US criteria for patenting an invention that fits into the definition of patentable subject matter. Novelty literally means that the exact invention has been known before. Keep in mind that the term obvious is a term of art. That means that lawyers have twisted and tortured its meaning so much that it can no longer be understood without the assistance of an attorney. The point is, it does not mean, quote, obvious in a common sense way. You and your team's thoughts on whether what you have created is, quote, obvious is not a good indication of whether you can get patent protection. We'll come to a better analytical framework to use in determining whether an invention can be patented in a minute. Now, the criteria for obtaining a patent is fairly consistent around the world. For example, in the European Patent Office, the criteria is stated as novelty, the same as us, and inventive step is their phrase for obviousness. The application of the European criteria typically leads to the same result as the application of the US criteria. Next slide, please. Now, the title of this slide is a little misleading. More accurately, what I'm going to describe is a practical way to identify the subject matter that you should consider patenting. In my experience, asking engineers and scientists to write down their inventions is not very productive. For most people, the term invention does not provide any analytical framework, just like the term obvious from the previous page. To many people, invention sounds very lofty and brings to mind Edison and Einstein. That is counterproductive to the process we're interested in because it inhibits people. We want a process or framework that is more akin to brainstorming where there are no bad ideas. What I've found is that a practical way to identify what we may want to protect with a patent is to make lists based on problems solved, advantages your approach or product provides over existing approaches or products, and what new features or functions have been created. Then you look at how those problems were solved, how the advantages are achieved, and how the feature is implemented. If the how is something your team created, it is more likely protectable. If they bought the solution off the shelf, it's less likely to be protectable by you. Next slide. Continuing in the vein of not discounting your solutions, improvements, and new features that's too small or too obvious, let's briefly look at what may have been considered a small improvement that turned out to be patentable and worth nearly $1 billion. The example is the Carnegie Mellon University v. Marvel Technology case that resulted in a $1.17 billion verdict for Carnegie Mellon. Ultimately, Marvel paid CMU over $750 million. Now, Marvel at the time was on chips that are used in hard disk drives. CMU's patents are for technology that's useful in reading data from hard disk drives. Generally, it can be considered a form of maximum likelihood sequence detection, trellis decoding, or Viterbi decoding that is applied to the signal being read from a hard drive. Note that CMU's people did not invent the Viterbi detector. Dr. Viterbi did that. What they did was applied it to reading a disk drive, and it improved the accuracy of the reading. The details aren't that important for today, but what is important is to keep in mind that incremental improvements to known or new problems can often be patented, and they can be extremely valuable. Next slide, please. Let's take a step now and briefly look at some of the details for the process for obtaining a patent. Now, here's a simplified timeline. Unlike copyrights, patents take time. And the joke is that the patent office can't measure time in increments smaller than a month. And that's why a lot of these things are in years. So one common approach, particularly for earlier stage companies, is to file a provisional application first. Filing a provisional can be about deferring decisions and costs. Now you then get 1 year to file a full utility application. That's what most people think of as a patent application. The trade-off with filing a provisional application is to make sure that it's complete and robust enough to support the later utility application. Now, provisional applications are not examined. They can be thought of as evidence of what you invented at the time you filed the provisional application. To the extent that that description in your provisional supports or describes your ultimately issued patent claims, that patent is entitled to the filing date of your provisional. That date matters because who filed first is one criteria for who gets a patent when two companies are pursuing patents for the same technology. Once the utility application is filed, it sits in line waiting to be taken up by a patent examiner. Now, in fields of technology such as software and electronics, the examiners are typically engineers or computer scientists, so they understand the subject matter. Now, the average amount of time to get your first examination, have it started, you get a communication from the examiner, is generally less than 18 months. However, it can vary widely based upon the specific technology and the backlog in that art unit. However, it helps that the Patent Office has over 8,000 examiners. Next slide. Thank you. Now here's a simplified foreign patent timeline, because again, you can pursue patent protection worldwide. In the software space, in the hardware space, people don't usually file all over the world. Pharmaceuticals, companies file all over the world. The high-tech area is more interested in Europe, China, and some varying handful of other countries, but the timing is the same. So you have 1 year from the filing date of the provisional, or if you didn't file a provisional, you have 1 year from the filing date of the utility application to file for international protection. That's typically done by filing a patent cooperation treaty application, or what we call a PCT. That application is primarily a copy of the US application and government fees. What the PCT does is put off for an initial 1.5 years the expense of filing in individual foreign countries and regions, which is what we call entering the national stage. Again, it's used like the provisional to defer decisions and costs, because with a little luck, the US application will be examined before that 18-month deadline, and the company would then be in a much better position to decide whether to incur the expense of filing in foreign countries. Okay, so when should you start this process? Next slide. Let's start with a simple rule that's intended to preserve all of your patent options. Before any public disclosure, sale, commercial use, or publication, decide and file your patent application. The vast majority of industrial countries require you to file a patent application before any sale, commercial use, or public disclosure. Filing a US provisional application satisfies this requirement. So if you file your US provisional before that, you have preserved your foreign rights and obviously your US rights. Now, if you find yourself in a position of having violated this rule, all is probably not lost. The US and a few other countries have some exceptions and grace periods, so you may be able to salvage some patent rights. So here's a scenario. Your team is hard at work trying to figure out how to implement this great innovation that you've thought of. At what point should you file one or more applications for the invention or inventions? Sooner is better than later. The vast majority of the world only cares about who filed their application first. If you are second, you lose. The US laws make it nearly the same here with some exception. The sooner is always better. Next slide, please. So here's the quick summary of the takeaway. A good way to start the patent process to look, identify problem solved, advantages, and new features. If you follow this process and file your application before any public disclosure, sale, commercial use, or publication, you'll be in a very good position to maximize the value of your patents and protect your innovations. Now I want to turn it back over to Bob.
Thank you, Richard. So now we're going to talk a little bit about sort of the new stepchild of intellectual property, and those are trade secrets. As distinguished from patents and copyrights, trade secrets are fairly new. They were not in any way part of the Constitution. I think the whole concept of trade secrets was really not something that anybody had until the late 19th century. And initially, they were created by the courts, not by Congress. And now there are statutes, both federal and state, that cover trade secret protection. States were the only ones who had statutes up until 2016, when Congress passed the Defense of Trade Secrets Act. But whether state or federal, the provisions are essentially the same, and the protections for copyrights are essentially the same. Next slide, please. So what is a trade secret? A trade secret is a much looser concept than either a patent or a copyright. There's nothing that gets registered with the government. A trade secret is whatever you want it to be. Now, you may have to support and prove that what you have is actually qualifies as a trade secret, but it's up to you to call what you have, the information you consider to be confidential, a trade secret. And so I mentioned that there are both federal and state statutes regarding trade secrets, but they are all uniform as to what actually constitutes a trade secret under the law. And so what that is something that's not generally known. And it doesn't have to be necessarily a high-tech invention. Some of the early trade secret cases dealt with information such as customer lists and things like that. And trade secrets are frequently, in addition to particular technology, business operations, profit margins, things such as that. So anything that's not known by others outside of the company. It has value to the owner. If something gives the company a competitive edge, that could be a trade secret. And importantly, the owner has taken reasonable steps to protect the information and to keep it secret. Without doing that, the trade secret can be easily learned about by somebody else. It's not going to be a trade secret anymore. It can lose its protection. And that's why you see in many tech companies that they have very strict sign-in procedures and that require you to keep anything you learn during your visit confidential and things such as that. It's mainly to protect confidential information and keep information a trade secret. Because of its nature, software is particularly well suited to be protected as a trade secret because it's easy to keep it secret, and it's easy to kind of categorize it as it goes forward. Next slide, please. Again, somewhat different than patents and copyrights, which have to be enforced in federal court. Trade secrets can be enforced in state court or federal court. And in order to enforce a trade secret, the owner must show that the information qualifies as a trade secret. In other words, that it's not known, that it has value, and that they've taken reasonable steps to protect it. If successful, the trade secret can obtain in order to seize the misappropriated information, get an injunction or damages. So if any party acquires, discloses, or uses a trade secret, they might be liable for one of those remedies. Thank you. Next slide. Yeah, perfect. One thing to say about trade secrets is, if something can be observed or reverse engineered, it's probably not a good candidate for a trade secret. So if you go into if you have something that's a mechanical device or something, and you're trying to trade secret, keep it protected with a trade secret, it may not be the best way to go about it, because somebody can go in and take apart the mechanical device and see how it works. The trade secret value of that is lost. But in terms of actually classifying something as a trade secret and protecting it, it's fairly easy to do because no registration is required. You just have to keep it secret. Okay, now that we've talked about these various tools, let's compare them and kind of see, what the advantages and disadvantages of each of them is. And the first is ease and cost of getting. As I said, there's no real cost to getting a trade secret. You just have to keep track of them. We always recommend to clients that they keep a log of some sort of everything they consider to be trade secret, and that they update that log on a periodic basis to make sure it's current. Copyrights registration can be achieved at a minimal cost in a very short amount of time. Patents, because it involves a lawyer throughout the process and could take 2 to 3 years, they tend to be more expensive. One thing that, when we talk about comparison, I think it's important to point out, and as Richard said, patent portfolios can be sold for hundreds of millions, and in some cases, even more. There really is no market like that for trade secrets or copyrights. So the value of patents is much higher in terms of actually being able to monetize them. But in terms of protecting, they all have advantages and disadvantages. In terms of the length of protection you can get, trade secrets, pretty much as long as you can keep it secret. Probably the most famous trade secret is the Coca-Cola formula, and that's been around for 130, 140 years. And because Coke has been able to keep it secret for that period, it's still a very valuable trade secret to them. Copyrights have 95 years of protection from first publication, and patents approximately 20 years. So much different terms in terms of being able to keep them as your own private property, and that should factor into how you want to protect something. Next slide, please. In terms of how broad or narrow the protection might be, trade secrets, again, they can be as broad as you want as long as you keep them secret. Patents, as Richard said, you can have very broad claims, you can have very narrow claims, you can have improvements to others' claims. it really depends on how you want to go about it. In my experience, the broader the claims, the more likely they can be invalidated. But that's still, something that you may want to think about, is how broad you want to make your claims. Copyrights, on the other hand, tend to be very narrow, as the only thing that's protected is the actual, expression. In the case of a book, the book itself, the way it's written. If you want to write a biography of Abraham Lincoln, the facts which make up his life cannot be copyrighted. It's only the way a particular author organizes and writes about those facts that can be protected. So it tends to be much more narrow. Richard, I don't know if you want to add anything about, the various merits of each of these.
Thanks. Yeah, patents are the most expensive, and at the end of the day, patents are almost always the most valuable, and they almost always, of these choices, have the broader scope. And they also, which we haven't really talked too much today about, is the opportunities for foreign protection. For patents, any country that you want to ever enforce a patent in, you have to have filed in, and you have to pay for all that. So there's budget decisions for patents, every year. And so you need to be thoughtful in advance and have a plan that supports your business goals. And it doesn't mean you have to necessarily, patents and trade secrets pretty much incompatible for the same concept. Patents and copyrights, not so much. You can do them together and come up with scope that's going to, again, suit the business goals. Next slide, I think.
Yeah, so Richard kind of touched on this, sort of the compatibility of each of these. Copyrights and patents, as Richard said, you can get both. I think for something like software, you're probably not likely to get both for the same software. But if you have a product that uses, say, some hardware and some software, you may want to patent the hardware and copyright the software. These are just options that are available, and you may want to consider. And as Richard said, there are budgetary considerations. It all needs to be kind of part of a unified plan on how to protect your intellectual property. Copyrights and trade secrets, not a particularly good fit. Kind of generalizing, trade secrets are not a very good fit with either of these, because the whole idea of copyright and patent is to make the information available to the public. And by its nature, a trade secret is something you want to keep secret. And so it's very difficult to conceive of a way you could protect something with both copyrights and trade secrets. Patents and trade secrets, it happens, but it requires a very, very close coordination and well thought out strategy, because you want to make sure that your patent disclosure doesn't contain anything you want to protect as a trade secret, because it gets published and it's available to the world. But there are certainly, I think, many companies that do protect some of their intellectual property with patents and some of their intellectual property with trade secrets. It may depend on how easy it is to reverse engineer something. You try to give that a patent, and something that is much easier to keep secret, you might want to treat as a trade secret. So as I said, it really requires a great deal of thought, planning, coordination, and just a strategy that you execute to try to maximize the intellectual property that you have. Richard, anything else on that?
No, I think that nails it. The idea here is to be aware of these tools and to have a plan, and then you can do lots of things. But if you just kind of go at it intermittently and not thoughtfully, you're going to get a lot less value.
And I think that we're at the end. Next, yeah. So I don't know if there have been any questions. If I would only add that we have our contact information here. If you think of something once we sign off, or you just want to run something by us without putting a question out to the group, please contact us. We'd be happy to answer whatever questions you have or provide additional follow-up information.
We have a lot of questions. Can you hear me?
Yes.
So I'd like to talk a little bit about enforcement. So some companies will feel like, you know what, we're a startup or a small company, and it's going to cost us a little bit of coin. And if someone comes out, we're really not going to be in a position to enforce. So let's just be first to market and not worry about a patent. Tell us why that may not be the smartest course of action.
I'll start. First of all, if your plan is only for 1 year, fine. But if you expect to stay in business for more than a year, patents last for 20 years. And hopefully you're either going to grow or be acquired. And acquirers in most tech areas are looking for IP protection. They want to buy a company that took the steps to have patents on file. And remember, it takes sometimes, typically, 3 years is not a long time to wait for a patent to issue. And now you're way past your first to market window. Before you even have a patent you can enforce. But you can do patent pending notices to alert the competitive landscape that you're pursuing patent protection. And you'll get the valuation bump if you're getting investment or being acquired for having patent applications, knowing that buyers will figure out, yeah, these are going to grant, and these are going to be significant barriers to entry to carry this product forward into the future. So the whole thing about, just be fast and I'll win, and don't worry about anything else, it's not applicable to most situations. There are some, particularly if you're doing services and things like that, but it's usually not the best bet. And at a minimum, you want to make sure that you got good advice and we're thoughtful about which steps you're going to take.
And I think, yeah, that's exactly right. I would just add, in addition to the valuation issue that patents bring with them, if this is something that you can't keep secret, that if what you would patent it would be something that others could observe through your product. If it's out there and it's successful, somebody could come in and copy it. That's just the way the world works. And if they're bigger than you are, they'll blow by you. And if you don't have patent protection for it, you're going to lose your advantage. And as Richard said, it could be a 1-year company at that point, or a 1-year product, certainly.
No, I think certainly a lot of the companies we run into Tech San Diego, it's an asset of the company, and I think Richard hit on it. It improves the price of the company. I want to tell you about an odd strategy that I know 2 companies have taken, and with their patents, because they had a patent. So these companies were hoping to be acquired, and they, it sounds like an odd way to use patents, but I have seen it used. So they've identified the most likely people who would acquire their companies, and then they had their lawyer start the conversation based on, you're violating my patent, we need to have a discussion. Have you guys seen any? I mean, is that a thing now, or maybe I just know of 2 companies, and maybe it's just a fluke, but using your patent position to go out and look for either investments from larger companies or even possible acquisition.
So yes, I mean, one thing it does is it gives you a way to get an investor or acquirer's attention. It gets you one step above, hey, I'm a cool company. You get to, hey, I'm a cool company and I've got these patent assets, and it makes you more interesting. And particularly if the competitor or the acquirer rather is in the same space. And now, acquiring me can also solve that infringement problem. It's delicate because you certainly don't want unnecessarily, because the problem with the care that needs to be taken is if they feel threatened enough, they can sue you first for declaratory judgment. Now you're off to the races. But it's pretty rare for people to want to go down that path because it just gets very expensive, the whole suing, when really you're looking to make a business deal. But it's definitely a legitimate way to get the attention of investors and acquirers.
Yeah, I agree. And I'm up in Silicon Valley, and I think investors are always looking for patents from the companies they're considering investing in.
So talking about enforcement a little bit. So let's say you've done the things that you want to do. You're a smaller company, and you noticed someone's kind of infringing upon that. You talked about the expense, but it's not always ends up in court. Oftentimes it's just, these are oftentimes litigated outside. So, what's your risk? Like Richard, mentioned it. Maybe you get sued back, and so talk a little bit about the enforcement and how companies should be thinking about that enforcement before they send we're going to sue you letter.
So a couple of things, about that. I mean, Richard's right. If you start menacing somebody, particularly a bigger company, they may turn around and sue you in order to gain the advantage. And so, but I think, the other thing I would say is, if you start down the path of, I'm going to sue them just to get their attention, or this, we'll sue them and then settle, you need to think that kind of strategy through, because once you file a lawsuit, it doesn't always go how you think it will, and it's not always easy to end as quickly as you would like. So this kind of goes to what we were talking about a little while ago. It's just important to really work through the strategy carefully and thoroughly. Look at what the cost would be of actually having to file a lawsuit. Find an attorney who fits your sort of economic model for this. Some firms will do this on a contingent fee basis, or some way where it doesn't require you to put a lot of money out there. Explore that, but have, as we've said before about other things, have a strategy. Don't just say, I'm going to fire off a few letters here and assume that they're going to come to me and want to give up. That doesn't happen very much in my experience. Anticipate what the other side's going to say in terms of a defense. How clear is the infringement? How clear is the patent language? How much of this is open to interpretation? Patent lawsuits are complicated. Patent infringement claims are complicated, and it requires really a lot of analysis before you want to go forward with it. We have a client that received a letter from a patent owner, and it really showed very little thought on the patent owner's side. And I think that he's wasting everybody's time, and we're able to respond and hopefully get him to go away. But that isn't, that happens, but it's frequently you'll end up in a skirmish that you don't anticipate unless you think this through at the beginning.
And I think Robert, I think that's good advice. And the thing that I've seen companies do is, you can't assume it's going to be negative, right? And so I've seen companies, knock on the door very gently of a larger company, says, we have this patent, can we have a discussion about this? And that's actually led to investment, right? And so, having your lawyer send a cease and desist and filing a lawsuit is really blocking you off from other possible opportunities. It's not always a negative connotation if you see someone, infringing upon your patent. Who knows what that may lead to. So I think that's a delicate dance, and you shouldn't assume maybe it's always going to end up in court.
Great point, but you have to be careful how you approach people.
The other thing you mentioned is, it's going back to enforcement. So you talked about copyright, and a copyright is attached to a work, kind of regardless of when you file that copyright. So let's say it's Tech San Diego. In fact, I did file copyrights on our logos, but let's say I didn't, and I have this logo around, and someone in town says, you know what, we can do a better job than Kevin in creating an association of technology companies, and we kind of like the logo you're using, so we're just going to use your logo, and we're going to start a new association. So if I'm using it in the market, can you, after the fact, then can you file the copyright after you notice someone's been using it?
The short answer is yes. The somewhat longer answer is, when you're talking about a logo, you're kind of reaching into trademark law, not copyright law. But Yes, you can register your copyright really anytime before or even after you file a lawsuit, as long as you do it pretty quickly after you file. It should be before, but it can be after, certainly after the fact, after you see somebody who's infringing your copyright.
You also talked about some on the enforcement issue. You also talked about some companies, taking on a contingency. Sometimes you think of contingency firms, you think of all those ads we see on TV, but there are legitimate law firms that will take some of these issues on a contingency if they're legitimate and there's patent involved. Does it increase if you did the original, if the firm did the original patent work for them?
Well, I think that's a two-part question. One is, are there good, reputable contingent fee lawyers out there? The answer is yes. There are some pretty, lack of a better word, sleazy ones. You want to stay away from those. You want to vet whoever you're using carefully, but there are some very good ones. As to the second part, do you want to use the same firm that did the patents? Possibly, if they're willing to do it on a contingent fee. If they're good. There are complications by having the same firm do the litigation, but they're not major complications. So yeah, I'd say, get the best lawyers you can to write your patents. Get Richard Campbell to write your patents, and hire the best lawyers to do your litigation on a contingent fee basis if that's how you want to do it. If they're in the same firm, great. If they're not, okay, go forward anyway.
On the issue of protecting the crown jewels, so I get approached by companies all the time. And a common thing is someone says, well, I want you to I want to talk to you about my company, but I want you to sign a non-disclosure agreement. I just don't do that, right? It's silly. Like, no one cares about your idea but you. Now, that may not be the case, but I think very rarely is someone going to walk into my office and, this is the greatest thing I've ever seen. And oh my gosh, I'm going to steal that and go develop that. And I think it often shuts them down into talking with people. So I won't talk to you unless you sign a non-disclosure, or I won't talk to a prospective investor. And some of these folks aren't as experienced in startups, and I think they overuse non-disclosure agreements. Do you see that? And as lawyers, how do you reconcile perhaps advising an entrepreneur that they're using it too much, where that's what you guys do, is advise clients to make sure they have non-disclosure agreements?
So that's a good question, because you're right. Particularly if you're looking for investment in things, there's lots of good investors who are not interested in starting a conversation with an NDA in place. Maybe if you get far enough along, it might be appropriate. And if you're lucky, your technology is applicable or protected through patent applications. That's one way to get rid of that concern, because everyone needs to keep in mind patent applications get published. So whatever's in a patent application is not going to be a secret. And then you can talk with them about your technology to the extent it's in the patent, without any real concern that you're giving anything away. That's a common approach. I tell entrepreneurs, the early stage people, a healthy dose of paranoia is a good thing, but it has to be healthy. If you stay in your room and never tell anybody anything, you're not going to move forward. And the world's not going to sign an NDA. You have to have that balance. And like I say, the patents are one good way to get a definable chunk of your technology that you can go into more depth with without the concerns that you might have otherwise when you don't have an NDA.
And I'm going to maybe approach this a little bit differently. I think it depends where you are in the process. Because obviously, if you get down a certain part of the road in discussions with somebody, you're going to start revealing financial information as well as technical information. And you're certainly going to want an NDA in place for something like that, regardless of how you feel about your technology. But I agree, you certainly don't need to do it the first time they knock on the door. I mean, so it's a balancing. What's the appropriate time to do it, and I think, again, up here, and I would imagine in San Diego as well, sophisticated investors and other companies, they're used to signing NDAs, so they're probably not going to be spooked by it too much. But you're right, you don't want to come across as some sort of wild-eyed paranoid who says, okay, you want to talk to me at all, you have to sign an NDA. It's question of timing and judgment.
Okay, we're running against our time now. So again, I just want to give a big virtual clap for Robert and Richard for presenting great information, very concise. Again, it's not legal information. You should always consult your lawyer. Robert and Richard are walking us through some of the big issues and giving us kind of some guide, not necessarily guidance, but what are the important issues surrounding this. So you should always consult your lawyer. I always recommend these two guys, top of the heap. So their contact information is there. Contact them if you like. Any last words before you go, Robert or Richard?
Yeah, Kevin, can we make the slides available to people who want them? I don't know how that's done, or they just reach out to us and we'll be happy to share them with them.
So Robert, this is actually will be on YouTube within around 24, 48 hours. So they'll have all those slides will be available.
Okay, great.
Okay. Richard, thank you as usual.
Kevin, thank you very much. We appreciate having the opportunity and very much enjoyed the experience.
Yes, thank you, Kevin, and thank you, Sarah, and thank you everybody for attending.
Okay, Sarah, any last minute comments to our YouTube audiences?
No, thank you so much for joining us, and feel free to visit techsandiego.org and click on the tech directory link to see our updated tech directory page.
Okay, thank you very much. Signing
Thank you.
off, Kevin Carroll, Tech San Diego.